Sure. Good morning. My name is Justin Mandel. I am a commercial real estate developer with Aspen Hill Partners.
Back in, may have been February, but definitely it was somewhere in February or March, Swider and Justin came in to see me to talk about the potential and their interest in a piece of property the county owns along East Walnut Driver Center. The county owns approximately 13 acres in that area, which actually goes from next to the driver center, wraps around the back of the driver center, the back of the armory, and includes the fire school. That's the entire parcel. The interest that is expressed is in 4.5 acres approximately that fronts on East Walnut Street as East Walnut makes the bend around to King Street. And so we talked a little about the history. We've had some interest in that property in the past that just didn't materialize, so I talked a little about that with them. There's now a proposed sales agreement for that, which has gone back and forth a little bit between the county and Mr. Mandel to fine-tune, I guess, the offer and fine-tune some of the provisions in there and of the agreement. And it has been it's been reviewed by council, by this county solicitor. The commissioners, you've each been given a copy of it. There were some changes to it just as recently as yesterday. And so at this point, maybe I'll turn it over for you to explain the offer.
The sales agreement that you have in front of you is for the purchase of, I believe it's 4.25, between 4 and 4.5 acres. The exact boundaries to be determined with a survey. So our process that we follow is a period of time to perform our due diligence, investigate the environmental circumstances of the property, the geotechnical circumstances of the property, and we also need to importantly apply and receive permits for our proposed uses, in this case, with the city, with PennDOT, and with the appropriate stormwater and environmental agencies. And so that process takes our study period, and the agreement that you have details the terms under which we will conduct our due diligence and provide for extensions where they may be necessary. And the diagram that you have clearly shows the area that we have an interest in developing for our tenants, and clearly delineates the wetlands area that we have no interest in developing or even abutting. It's the opposite side of, I believe it's called Metro Drive. The proposed purchase price is $700,000, which is above the appraised value of the property. There are a number of deposits that are detailed in the sales agreement. We're proposing to place $5,000 for the initial 9-month study period. We have the option to extend our study period for 4 additional 3-month periods at a cost of 90 days. At a cost of $5,000 for each of those extension periods. We've also incorporated 2 additional extensions that come with deposits that are non-applicable. And so the effect of those deposits is that they will increase the sale price. So if our study period takes in excess of the initial study period, the cost of the deposits is added to the purchase price.
And those costs are $10,000 each?
That's correct. So if we, in fact, take the entire study period that's detailed here prior to closing, we will deliver $720,000 to the county at closing, less the applicable deposits of $40,000. Sorry, $20,000.
They would apply to the sale.
Right. Basically, what we're trying to structure here is a situation where if we actually need additional time, there's a benefit to the county. It increases the sales price to you.
Do you have more? Do you want questions as you go? What is your preference?
I'm happy to field questions at any time.
2 things that you've said so far trouble me, and one is that when the county was first approached, my one requirement was that the wetland be preserved. And I was told that the company would be willing to pay for making that happen. In other words, the subdivision fees and things like that, and because you were not interested in buying the whole parcel once you learned out the sensitivities of that precious resource that we have at the headwaters to the Quittapahilla Creek. And that being said, there is nothing in this agreement that says you will pay for the subdivision to preserve that land. Either you keep that word or you don't, and if you don't, that speaks to me that I don't want to vote for this because I don't find it in good business practice to make a promise that's not kept. And the second question that I have is the initial $5,000. It's my understanding the company wants to walk away and get half their money back, and $5,000 does not cover all of our expenses. And I'm talking about additional assessments or appraisals and attorney's fees and things of that nature. That $5,000, none of that should be refunded to the company if you walk away from it. You're approaching us to buy it. You've done a lot of due diligence already. $5,000 is not going to break you, but it will cover our expenses. So I don't think that that's an acceptable part of the agreement.
To the first question, sort of being the intermediary between Mr. Mandel and the commissioners, I believe what he expressed, and as it says on this photo, this aerial, their recommendation was that be put into a conservation easement, and I think the offer was that they would be willing to assist with that. Now, I think where we are is a definition of assist, and what that was intended to mean. That could mean monetary, it could mean facilitate. I don't know. So I just wanted to clarify how it was phrased, and maybe from there you could. Then it's you.
Okay. Well, I think what's important, Commissioner Litz, is what you believe you heard. So I don't want to dispute anything that you've said in that regard. However, we do not have any interest and never have had any interest in the portion of the county property that is on the other side. It's on this exhibit. It's Career Drive. I believe it's called either Career Drive or Metro Drive. But any of the land that is to the west of that road has never been part of our development. Has never been contemplated for development, at least by my company. We approached the county because we have an opportunity to develop the vacant parcel that's directly adjacent to the driving license center, and that was our main interest. The discussion that I've had a couple of times with the county administrator, Jamie, and what I attempted to convey in our original meeting was that we have experience in other projects where there have been sensitive environmental conditions, and we've and if those environmental conditions exist on the properties that we're proposing to purchase or that we have purchased, we work with the appropriate agencies to protect those areas to either meet or exceed our legal obligations or the desires of the community and the townships in which we work. In situations where those sensitive environmental parcels are nearby, or in this place, in this area, a circumstance not part of the proposed development. My intention was to certainly propose a solution and advise on how that might be accomplished. If there's specific cost to the county as a result, and this I think leads to your second question, if there's specific cost to the county as a result of evaluating and monitoring our proposal, then we would certainly not want to inconvenience the community or work through our due diligence in such a way that it causes an undue burden on the county. So, I mean, if you could perhaps detail specifically what you have in mind, I could try to, accommodate that. But,
To make it perfectly clear, the property is only available if it's subdivided, which would be, right now it's preserved through the county, but to be subdivided would preserve it. To facilitate that, it costs money to do the subdivision. It was my understanding that your company would pay for that subdivision as part of the process.
I think our intent was to pay for the subdivision of our parcel, and you're suggesting that we also pay for the subdivision of the portion of this exhibit that's delineated as wetlands. Is that
Correct.
correct?
Correct.
So if you have this
Yes.
exhibit in front of you, you're talking about the hatched area, which is an approximate triangle to the west of the road.
Yes. It's one parcel. To subdivide it would be the only way to preserve it.
I don't have an engineering training. I couldn't advise on whether or not a subdivision is required for any sort of conservation easement or any sort of protection. I mean, the wetlands themselves, are they protected
If it's
today?
all one property, how are you going to buy it if it's not subdivided?
Well, we're proposing to subdivide the parcel that we would like to develop.
And do the description of the deed for the parcel for the county as well. You would end up with 2 deed descriptions instead of 1 then, is that correct?
That is correct.
So you would pay for all of that?
I think what is being discussed here is that the area on the exhibit that shows the hatched area that defines the wetland, presumably that would become its own parcel that would be transferred to a conservancy, yet to be named, not sure. But that would be its separate parcel. If you were to purchase then the 4.5 acres, the county would only be remaining with that rectangular piece that goes from Career Drive out to the back of the fire school. 2 parcels would come out of this one.
In other
2 would
words,
be
there would have to be
subdivided.
surveys and
Right.
that sort of thing,
So-
filing fees, and that all should be done at their dime because they want to buy the 1/2 for development.
So what's being asked is if you would be willing to not only subdivide the parcel that you were interested in, but then to also subdivide off the wetland area so that the county can transfer it off to a conservancy.
And I don't understand how one can be done without doing the other. I'm just saying who's paying
Well,
for it.
it could be done without doing the other, because then the parcel would remain this sort of pennant flag shape without that. So there would still be there is no dividing line right here going across Career Drive, so the parcel would end up being this without that on it.
But
So,
the parcel that remains has to have a deed description.
well, it would say
wetland.
that this was divided off. Dave, maybe you can explain
Well,
that.
so I want to make a couple of points here before we move on. So the purposes of this drawing is to illustrate a property description of the parcel that we wish to purchase. It is not intended to be a legal description of the current property or to be an exact survey or anything like that. So, I don't know what the exact boundaries are of the larger county parcel, because there were a number of different tax records that we drew up, that we pulled when we originally drew up this agreement. And I know that we did in fact change it at one point because we didn't have exactly the right deed number. So what we could do is ways in which this wetlands can be protected. But I certainly couldn't say that we would pay any and all costs associated with that, because I don't know what they are right now. And I don't know how big the property is, and I don't know what surveys would be involved or additional fees or anything like that. So it's outside the scope of our development, and we would be happy and willing to cooperate with the county in any way possible to the extent that the county wishes to preserve the wetlands, we support that. But I can't promise that we would pay any and all costs, because I don't know what those are, and I don't know what the larger description of the property is. We haven't been able to actually see that. So when we do our survey, we're gonna survey the boundaries of the proposed development. Because, for example, if this is it could be, I think at one point there was a 30 or 40 acre
Yeah, this
parcel.
is, yeah, what we
You know,
have.
We wouldn't be able to survey the boundaries of an entire 30 or 40 acre parcel. It's really beyond the scope of what we've contemplated here.
What we still own is residual of a very large piece of property that went all the way over to
Cedar
behind
Haven.
Med Ed, which is where the Alms House originally was. I mean, goes back to the 1800s, I think, this deed. And so just as pieces were parceled off, including the prison, including Cedar Haven, including the CTC, and, you know, over the years, over the hundreds of years, these have been deeded off. This is still the residual, so that's why the deed is somewhat complicated.
If Commissioner Litz's point is that their subdivision would accomplish that this one parcel would be broken into two, is what they're proposing right now. If she's suggesting that this one parcel be broken into three effectively.
Thank you.
So that the wetlands area be separated off. I think the point is kind of a fair point, that the transactional cost, while you're having a survey done, you're preparing legal descriptions, and you're doing a subdivision approval process through whatever municipal entity you have to go through to do that. The additional marginal cost to accomplish from two parcels, what you want to achieve, to three now, is probably not that substantially greater. Now, whether it can be achieved with the required setbacks and zoning requirements for lot size and things like that, and anything else that might apply, I don't know. But just the transactional cost of the engineer and other fees and things like that, the surveyors, would not be that much greater if they're already on site doing that work. I understand that, if that's what I think you're saying.
That's exactly what I'm saying.
We can make a contribution towards the wetlands conservation. I'd be very happy to do that. My concern is that, you know, to your point, I'm sorry, I don't know who you are.
He's our solicitor, sorry.
Steve Warren.
Okay, very good, nice to meet you. So if we're only doing a survey, you know, in the direct vicinity of the property, and we're only doing subdivisions regarding that, I agree with you, there is a marginal increased cost to doing so. I mean, it might be double, but it's not going to be orders of magnitude greater. However, if we're gonna be required to survey a much larger territory, because that's how big the existing piece is, and to do a deed description for the remaining 30 acres or whatever it is, that could be an addition, that could be significant, $30,000, $40,000 in survey costs. That's what I'm uncomfortable committing to.
Yeah, I understand what you're saying.
So
Certainly a greater cost.
I'm comfortable making a contribution to the wetlands, but I would want, you know, within reasonable limits, I guess, is how I would.
Dave, what would it normally cost to do a subdivision for a wetland of that size?
I couldn't even begin to speculate, honestly. I really
To survey it
If we
and
had
come up
folks
with a
from
deed
county planning
description?
here, maybe they could give us a better idea, but I really couldn't begin.
One example, to subdivide Cedar Haven and the prison, which were all on one parcel at one time, I believe was $8,000 to, now that was a large parcel, but I think that was all included. That was representation at South Lebanon Township and all sorts of things. So that's to give you an idea. You know.
So, okay, so.
Commissioner,
Yes, I'm sorry.
I'm satisfied with the contribution aspect. I think they, from the beginning, said that they would assist in that, and I don't hear anything that they're retreating from their original proposal. I think they've been cooperative and responsive to our going back and forth and negotiating in good faith. And I think at this juncture, I'm satisfied with their agreement to contribute to the cost of that.
Would the contribution be not to exceed $8,000, whatever it costs us to do the subdivision?
I was gonna say 5, but, I mean, in the interest of you know, an olive branch, I mean, we could say not to exceed $8,000 at the time of closing, to be applied towards the subdivision of the wetlands as delineated in Exhibit A.
Thank you.
Can you share in any way what the future use of that parcel will be?
Not until we have a signed agreement, and then I can talk a little bit more about the proposed development. It is a commercial development.
It's commercial.
Yeah. We've done a number of developments. I introduced myself to the commissioners in the past, and you're
I'm John Latimer, I'm with the Lebanon Daily News.
very nice to meet you. So my firm has done a number of different commercial developments around Pennsylvania and adjacent states. We work mainly with national credit tenants. I think the county and the community will be really pleased with this development once the details emerge. We'll obviously go through the normal planning process for the development.
Can you tell me the Career Road or Metro Drive or whatever that's called, is that an access route or is that kind of a private road? It's just can be a very congested area there. So I'm wondering if the status of that road is part of the project and whether it's open to you.
That's a good question. We have not done extensive due diligence at this stage. Normally that comes once we have the property under agreement. That's when we begin to spend our money on engineering and permitting and things like that. If that road is a county road.
It is, it's our only county road.
That's the county road? Okay, so then the county would have jurisdiction over any accesses that our proposed property would have to that road. There's likely to be significant off-site attention paid because it is a congested area, because it sits on a corner with some unusual, let's say unusual traffic patterns. It's actually part of what attracts us to this project is the opportunity to redevelop it. So, at this point, I couldn't say, what the county might or might not want with regards to that road.
And do you have any developments in Lebanon County currently?
But we do, yes.
Can you share what they are?
The Sheets of Five Guys and associated businesses on 72 and Rockerty Road is one of our developments.
Thank you.
I guess I didn't hear a resolution on not taking back the $2,500 of the first $5,000 deposit.
So as I just mentioned, so we structure our agreements in order to allow us to remove any of the potential deal breakers up front. So my time is limited and my team's time is limited. We don't want to extend an agreement for a long time unnecessarily. And what we do up front is establish whether or not the project has any potential deal breakers. There are two kinds of we call them deal breakers. There are kinds that we can control and there are kinds that we can't control. The things that we can't control are things like environmental problems. If we do an environmental analysis and it turns out there's contamination on the property, it's expensive to remediate, or there's mine subsidence, or there's a historical easement that crosses the property that can't be removed. Those are the things that we discover in our title search that we do up front. And we begin spending money to do all of those engineering analysis, title searches, and other aspects of due diligence. There are also elements that we have control over. Those are things like permitting, cooperation with the relevant authorities, going through the planning process and things like that. So what we want to eliminate up front is, and what we spend our money on up front is eliminating aspects of the project that may not allow us to continue. And that's why we ask for some refundable deposit, because we don't know if those things exist at this point. And so we ask for the initial deposit to be partially refundable in order that we are not unduly exposed in the situation where we have to withdraw from the project for one of those reasons that we can't control.
If your deposit was $50,000 or $100,000, I would understand that completely, but not for $5,000. As I expressed previously, we have expenses as well. And we are cooperating with you to allow you the opportunity to develop that area. I don't think $5,000 split back to you, $2,500 is reasonable. I think the $5,000 should remain with the county.
And may I interrupt that? I feel they and we have negotiated to this point in good faith, and I'd like to move on from this and see if the vote for the agreement as it stands with the concession on the assisting with the wetlands is going to fly or not.
I also had questions and want to make sure that you are aware that UGI worked on a pipe on the corner of that property, and I do not know if it is within the right-of-way or within the boundaries of that property, and 3.01 clearly states about easements and restrictions that you be notified. So I wanted to let you know that there is a possibility of UGI being on that corner. Does that change your mind in any way?
There is, you're talking about sewer or water or some utility that's not on the roadway, but it's in fact on the property.
I don't know which it is because I don't know where the survey lines are.
Right, and neither do we. So I think
But I wanted to make you aware of it in case it is there. It says that we must disclose any rights of way, and that's a potential right of way on that property.
It's right along the road's edge, so
Sure.
it may be in the right of way, it may not. And then there may be other utilities there, so my understanding is those are things that you'll sort out once you
correct. And
do your search.
We'll do a title search, we'll do a survey, we'll do all of those things to establish the conditions of the current conditions of the property. I hope there are utilities there, because actually if there aren't, then we're not gonna be in trouble. I mean, I appreciate the information, it's very helpful for us. At this stage, I don't think that it changes anything.
Okay.
For us.
And then my final comment, again, dealt with the 3% broker fee for the county. We weren't looking to sell it. We cooperated. We shouldn't be paying 3%. We're our own agent in this case. So I think that the buyer should be paying the full amount of 6%.
Okay. We did not approach we approached the county, but I mean, it's, if we pursue some work and then we walk away, you are left with some money. The offer, and now with the addition to some of the additional costs is in excess, I understand is in excess of the appraised value of the property. So that's to compensate for these sorts of things. That was our intention anyway.
Well,
Okay.
I don't think it's appropriate. I'm just telling you that. I think it's, you should be paying the full 6% from the buyer's perspective. They
Normally we
hired
pay-
Mr.
normally we pay
Swider.
no percent.
They hired Mr. Swider, we did not.
I mean, normally our agreements are that actually the seller pays the whole commission.
Exactly.
Even
The seller.
The seller.
Not
So
the seller, the buyer. We're the seller.
I understand.
But the
And
buyer should
normally
be
in our
paying.
agreement, normally what we do is have the seller pay for largely all of the broker's commission.
All right, as concerns the not to exceed $8,000 commitment, are you just going to put that in the form of a letter to Jamie, or do we need to incorporate that into the agreement?
I can include an amendment to the agreement.
Okay. All right, with that additional commitment being included, do I have a motion to approve the agreement?
So moved.
Do I have a second?
I'll second it.
All right. Have a motion and a second to approve the agreement of sale, including the not to exceed $8,000 commitment for the transfer of the wetlands. All those in favor indicate by saying aye.
Aye.
Opposed?
He didn't vote.
You might have voiced over.